Hi everyone, welcome back to my channel. Today's video was highly requested and it is about the opinion letter that was released by Chief Justice Bruce White pertaining to the Johnny Depp and Amber Heard case in Virginia on the 4th of January 2021, and it's with regards to Johnny's objections to Amber's counterclaim. You'll remember the counterclaim, right? Where we were all accused of being bots, and Johnny is the mastermind and puppeteer behind this social media movement in support of him. So Chief Justice White was asked to consider the following. Firstly, whether a declaratory judgment should be made in Amber's favor. Now, we've talked about declaratory judgments in great detail a few months ago when discussing her counterclaim. So if you don't remember what that is, please check out that video. In summary, it's a declaration of someone's right. So for example, a declaration that Amber is protected by anti-SLAPP laws and has the right to express herself. Secondly, whether Johnny's statements are actionable under Virginia defamation law, so whether Johnny's statements are defamatory. Thirdly, whether Amber has alleged sufficient facts to prove a violation of the Virginia Computer Crimes Act, and this is where, of course, the bots come in. Fourthly, whether Amber's counterclaims arise out of the same transaction as Johnny's complaint, which is very important with regards to the statute of limitations, because in Virginia, defamation cases have a 1-year statute of limitations. So if 1 year passes from the date that the statement was made, no action can be taken. And again, for anyone who hasn't watched my previous videos, this is something that we talked about in great detail when discussing Amber's counterclaim. And finally, whether Johnny himself is entitled to anti-SLAPP immunity for his statements. Because I have at least 3 videos, I think, dedicated to discussing Amber's counterclaim, I won't be rehashing what she states in her counterclaim. So I'm going to go ahead with this video, assuming that you have the knowledge and the context to understand what we're talking about. And if you don't, again, I will link the counterclaim videos in the description box. So if you want to catch yourself up and get up to date, then feel free to do so, and you can always come back to this video later. So first, the judge talks about Amber's request for a declaratory judgment to be made. As you'll remember from previous videos, Amber's main argument is that her statements in the op-ed are expressions of opinion that are protected by the First Amendment. Now, this request of hers was denied, and the main issue that Chief Justice White had is that she is asserting both a defense of freedom of expression pursuant to Virginia's anti-SLAPP laws. So that's her defense. And then she's also asserting that she wants a declaratory judgment to the same effect. So she's asking for the same thing twice. And so the judge believes that this is a waste of time and resources. If your defense is relying primarily on the anti-SLAPP laws, then why should we also waste time considering a declaratory judgment that seeks to make the same order, really? Specifically here, you can see the judge stated that to hear both Ms. Heard's anti-SLAPP defense and her declaratory judgment counterclaim would equate to adjudicating the same issue twice. The judge further goes on to say that since this court would not rule on Amber's declaratory judgment counterclaim until after all matters have been tried, the purpose of a declaratory judgment, which is to resolve disputes before the right has been violated, is defeated. So what he's saying here is that the purpose of a declaratory judgment is to protect someone's right before they're actually infringed upon. But here, because of the nature of the claim, the court can't properly consider or declare that Amber is immune before the matter is tried. Another aspect of Amber's argument of granting her a declaratory judgment is that if the case against her could be dismissed at any moment, or dropped by Johnny, she would be deprived of the opportunity to recover attorney fees. But the judge points out that this is not the case, because even if Johnny's claim was dismissed, she would still go ahead with her counterclaim. And Virginia's anti-SLAPP statute is only concerned with awarding reasonable attorney fees if a case is dismissed, but not when that defendant also has a separate counterclaim that they still want to go ahead with. For these reasons, the court declined to grant Amber a declaratory judgment that she is immune as per Virginia's anti-SLAPP laws. So Amber is claiming that Johnny made defamatory statements against her, and once again, this was discussed in a previous video. Johnny argued in response that they were not defamatory and that, in fact, he was merely repeating what was being said and relied upon in his actual complaint, which is protected by absolute privilege, or he was merely defending himself. So the main element that Johnny is fighting against and is insisting does not exist in his statements is the requisite intent to defame Amber. So first, the judge talks about the requisite sting. So does the statement come across as a statement of fact that is defamatory to Amber's reputation? So here is where the judge lists the 8 statements that Amber is relying on to claim defamation and defamation per se. A is in relation to Johnny's interview with GQ from November 2018, and then B through H all pertain to Adam Waldman, who is considered Johnny's agent in this situation, where he has told multiple publications, predominantly in the UK, that Amber is orchestrating a hoax. The court found that, particularly in the context of today's climate with the Me Too movement, these statements contain the requisite sting for an actionable defamation claim. Johnny also asserted that his statements and those of Adam Waldman's are protected opinion statements. But the court found that although these statements can be understood as Johnny and Mr. Waldman's opinion of what happened, they nevertheless imply that Amber is lying. So these statements must survive the objections or the demur, because whether Amber is lying or not is a fact that is capable of being proven true or false. So only statements of fact can be defamatory. Opinions cannot. Calling someone a liar when it comes to things that can be proven or disproven stops it from being purely an opinion, purely because it can be proven or disproven in a court of law. Johnny also argued that his statements are protected as fair and accurate accounts of his lawsuit. So basically, whenever Adam Waldman talked about Amber orchestrating a hoax or making things up, then that was directly related, or a summary rather, of what they were arguing in the lawsuit itself. Now, the judge disagreed with Johnny here. So although a lot of what Johnny said is also contained in his complaint, the statements didn't appear to have been made in the context of attempting to recount litigation. Instead, the judge found that Johnny made factual assertions that did not fairly and accurately summarize the litigation, and accordingly, his statements are not protected. I also want to say that I will be reserving my opinions and my analysis towards the end of the video. Now, Johnny also stated that particularly with the November 2018 GQ magazine article, his statements were made in self-defense and are therefore privileged. So for that interview, he was questioned about Amber's allegations, and in defense of himself, he said, "She's lying. I never did anything to her." Now, once again, the judge disagreed with Johnny. He found that because Amber has alleged facts in support of a showing of malice, so Amber is alleging facts that prove Johnny said these statements with malice, the court can't properly decide this claim on demur. So it's not that he completely disagrees with Johnny, it's just that he can't adequately decide whether Johnny's statements were made in self-defense or with malice at this stage. So again, this is all contained in Amber's counterclaim. She presented some examples and some evidence of Johnny's intent to ruin her career, for example. You know, those texts that he sent, I think they were to Christian Carino, where he says, you know, I'm going to ruin her. She's done this to herself. But I do want to point out, the judge isn't saying he believes these assertions, but he can't at this stage, purely at the demur stage, decide whether there is merit. Now, although this sounds like bad news, just bear with me, because the November 2018 GQ article is very problematic for Amber in an entirely different area. So I just want you to bear that in mind as we progress, because when we get to a further stage of the opinion letter, you're going to realize that everything's going to go downhill for Amber, particularly with regards to many of the statements that she is relying on in support of her counterclaim. Now we get to the Virginia Computer Crimes Act, where the demurrer was sustained, which means it's successful. Johnny's objections are successful. Now, I've gone through the elements of this particular legislation in great detail in at least 2 videos, so we won't be doing that here. The judge found that none of Amber's allegations satisfy the elements of the legislation. Another thing I want to point out is the judge actually echoes an argument of mine that I made in my videos when I said that the messages that Johnny sent to his personal friends, Paul Bettany, Christian Carino, they were all sent in private. This was a man venting in private to his personal friends with no intention of publishing these text messages, particularly to Amber, because they only came out as evidence against him in this proceeding. So it's not even evidence in support of him. He wouldn't have wanted these texts to come out, if anything. And the judge states that here. He says that, rather, it appears that Mr. Depp texted those statements privately to 2 of his friends. And Ms. Heard has not alleged that Mr. Depp intended for her to see them. And a major component of the Virginia Computer Crimes Act is that the intention is to inspire fear and intimidation in the other person, being Amber in this case. But if a text message is always meant to be private, that intention is impossible to satisfy or to prove. And so everything pertaining to her claims regarding the Virginia Computer Crimes Act fails. Now we get to the upside of all of this, because now we consider the statute of limitations. Now, this is a huge problem for Amber that I talked about in detail when I discussed her counterclaim. A lot of the statements that she is relying on as defamatory do not fall within the 1-year statute of limitations. The judge found that statements A through E are barred by the statute of limitations. And as you can see here, this includes the GQ magazine interview. Now, as we discussed when talking about her counterclaim, she's alleging that the statute of limitations doesn't really apply to her in this situation because the statements that she is relying on arise out of the same transaction or the same occurrence that led to Johnny filing his lawsuit. Now, the judge goes through a lot of case law here that we don't have to go through, so we're just going to go straight to his application of the law to this current situation. So he found that while both Amber's allegations and Johnny's allegations originate from the same set of facts, being their dispute in 2016, he still found that Amber's statements were made in the Washington Post, whereas Johnny's statements, or those of Adam Waldman, were made in GQ magazine, People magazine, the Daily Mail, etc. So the judge found that the only connection between the claims is in origin. They both stem from the 2016 incident. Because these claims arise from statements made in separate publications on separate dates and by different people, the court is not persuaded that Mr. Depp could have anticipated at the time of filing his complaint a need to defend against any statements made to other publications. So basically, Johnny was blindsided. There was no way that he could have anticipated the GQ magazine article and the other articles being brought into this case because they are so unrelated. The lack of relatedness and failure to reasonably put Mr. Depp on notice of a potential counterclaim compels this court to grant the plea in bar to statements A through E. So it's not fair to Johnny if the counterclaim was to be upheld with regards to these statements because he was not put on notice. And this is why I told you when we discussed the GQ magazine particularly, it may sound ridiculous and infuriating that Johnny's self-defense claim was not necessarily accepted by the judge. It was irrelevant to even worry about that because at the end of the day, the statute of limitations ran out. And as I argued in my counterclaim video, they were completely unrelated. Finally, the judge considers whether Johnny himself is entitled to anti-SLAPP immunity. The judge found that there was no support for the notion that Johnny's statements are on matters on public concern. Another issue the judge had was that Johnny's counsel neither argued nor addressed this point during oral arguments or in their reply brief. And lastly, he states that Amber has alleged sufficient facts in her counterclaim to demonstrate that Johnny may have made these statements with actual malice. And as you can see from here in the screenshot, actual malice is actual or constructive knowledge or with reckless disregard for whether the statements are false. Now, I've used this exact same argument to argue against granting Amber immunity as per Virginia's anti-SLAPP statute. My main issue with her continuing to assert immunity was that if you read the actual immunity clause, it states that this immunity does not extend to statements made with actual malice. And the whole point of a trial here is to determine whether they were made with actual malice, because if you'll remember, public figures like Johnny and Amber have a much higher standard to prove defamation. They must prove that it was made with actual malice. So the negligence standard applies to the rest of us ordinary folk, private citizens, and actual malice applies to public figures. Since it's such a key element of proving this case, it can't simply be decided on a whim without trying the facts at trial. So for the same reasons, Johnny's claim of anti-SLAPP immunity must also fail because Amber is a public figure and actual malice plays into the elements that must be proven to prove defamation against her. So in summary, Amber's claims of defamation and defamation per se were successful, so they have survived the demurrer. Amber's claim that she is entitled to a declaratory judgment that she is immune has been dismissed. Amber has failed in her claims of a violation of the Computer Crimes Act. Statements A through E, relied on by Amber, have failed as the limitation period of 1 year has expired. However, count 2 with respect to statements F, G, and H survive, and that's because they are within the statute of limitations. I don't necessarily agree with the judge's reasonings pertaining to the defamation and defamation per se allegations made by Amber. So I still very strongly believe that Johnny's statements were made either in self-defense, which granted is irrelevant because that particular statement will not progress as it is beyond the statute of limitations. But then there are also the statements that survived, and all three of them were made by Adam Waldman on behalf of Johnny. And I still believe wholeheartedly that these statements were made in direct relation to the civil lawsuit that Adam Waldman was at that time involved in and in charge of. So I still view it as a lawyer commenting on his client's case, as opposed to a lawyer or a person just stating things that are defamatory against another person. He wasn't just going out there and making these allegations without having any relation or connection to the case. So it is unfortunate that these three statements survived the demurrer. Now, don't forget, just because statements survive the demurrer, that doesn't mean that when they get to trial, the jury will buy Amber's story. A demurrer isn't a hearing on the merits of a case. So it's not a stage where the court is allowed to assess the merits or the strengths of an allegation. As per Virginia law, a demurrer tests only the legal sufficiency of the factual allegations. Accordingly, the court must accept as true all properly pled facts and all inferences fairly drawn from those facts. And this is important to point out because I can see how this can be interpreted as the judge accepting Amber's allegations. He is not entitled to, at this point, to assess whether her allegations have merit or not. At this point, it's all about the legal arguments that are being made. Are they sound? And according to him, they were. So with regards to these last three statements, he believes that there is enough to send him off to trial for a jury to assess the merits of the claims. Other than that, I am pleased to see that the plea in bar was, for the most part, successful. A lot of the statements were barred, A through E. Only 3 made it through. That's, of course, good news. We need to take our victories where we can get them. And I understand that a lot of people would still be fuming about the fact that the 3 survived, but we need to look at this as the big picture here. So the entirety of her allegations regarding the violation of the Computer Crimes Act have failed. And then we have 5 out of 8 statements dismissed because they fell outside the limitation period. I don't know about you, but I tend to be an optimist, and I'm not saying that this means Johnny will win. I'm just saying that now he has a lot less to contend with when it comes to the counterclaim. All right, that's it for this video. I hope it makes sense. I hope I helped to clear things up for you. I actually did it on the fly because I didn't really have time to read it in detail before making the video. As always, don't forget to let me know what you think in the comments below. If you enjoyed the video, then please don't forget to hit that thumbs up or thumbs down if you didn't. And if you aren't already subscribed, please don't forget to hit that subscribe button. Thank you so much for watching. Stay safe, and I'll catch you in a future video.